Thomas Pringle.
Thank you, Lachlan Corla. Well, this bill has been welcomed by some of the parties speaking in the House. I think there is, while it attempts to do something in relation to admission policies within schools, there is a lot of problems with the bill, and it does need to be addressed further at committee stage to correct it. There are three aspects of concern in relation to discrimination in our school system. One, schools can refuse entry to a child based on religion, even if it's not oversubscribed, and even if the child is a designated school by the NCSE or Child and Family Agency. It can discriminate by not providing an alternative to religious instruction, and it can discriminate by prioritising children who are related to previous students. Overall, the bill fails to echo best practice in terms of including the best interests of the child as a measure for educational standards. At a minimum, the best interests of the child and the wishes of the child should be reflected from the outset in admissions policies and throughout the school day. The bill obliges schools to publish admissions policies, but it doesn't oblige them to change them if they're wrong. And this bill won't limit the practice of discrimination. The National Council for Special Education or the Child and Family Agency can designate a school for a student where they have not secured a school place. However, this bill allows for that school to appeal their decision based on the refusal arm of the current exemption on religious grounds. The best interests of the child should be the primary standard by which the National Council for Special Education and the Child and Family Agency have regard to making a designation and decision not to designate a school. And there is also a need to include parents, the right for parents to make an appeal when a school has been designated by the Child and Family Agency or the NCSE when that parent believes that the designation is not in the best interests of their child or failed to take into account the wishes of the child. The Appeals Committee provided for in Section 66 should be required to apply the best interests of the child as a primary consideration when assessing an appeal, and be required to take into account the best wishes of the child as well. Furthermore, children in a particular region with a specific disability could be required to attend a school not of their belief in order to access the support they need, or that school could refuse admission of a child with a disability, claiming it would preserve the school's ethos. While there is separate legislation before the House and before the committee in relation to the so-called baptism barrier, I think it's important to address it as well here tonight, because there can't be comprehensive reform of school admissions policies without the reform of the baptism barrier. The Irish Human Rights and Equality Commission have repeated this assertion and calling for the baptism barrier to be removed, and they recommend that the Equal Status Act would be amended to give effect to the principle that no child should be given preferential access to a publicly funded school on the basis of their religion. Three constitutional experts have given legal opinion in relation to how the Dáil can actually legislate for the power to eliminate, and has the power to eliminate, the baptism barrier, and the Dáil can do that immediately without taking account of the Constitution, but not using the Constitution as a barrier to actually take an action in relation to it. They've outlined that the Oireachtas has the power to impose reasonable conditions on the provision of funding to educational institutions, and this includes requiring that all publicly funded schools must accept all children of all religions and none on an equal basis. And that can be addressed and should be addressed, and this bill shouldn't be taken in isolation in relation to the baptism barrier as well. The bill doesn't contain provisions to enable the Minister to regulate the use of an admission policy which restricts the admissions of students who are related to previous students either. And there is a lot of concerns as well in relation to whether the 1998 Act actually has better provisions than that is proposed in this legislation to allow and control the admissions policies in relation to schools. Also within the religious instruction, the bill obliges schools to publish arrangements for students not taking religious class, but without guidance or regulation on how they should actually do that. And the minimum standards on the nature of exemptions for students who do not take religion class are not included in this bill either. It does not attempt to move religious instruction towards the end of the day or outside core school hours, which really should be the objective on a publicly funded school system, that the school should facilitate religious instruction maybe outside of hours rather than having it as a core part of the daily class, and that would mean that children wouldn't be discriminated against if they didn't want to opt into religious classes. So state-funded schools should accommodate and respect diversity across all 9 discrimination grounds in the equality legislation, including the baptism barriers, as I said before, and the right to opt out of religious class as well. Thank you.
Next.